Oh my bad. Good afternoon, everyone. Ms. Rivers, are you able to hear us?
Yes, I can. Good afternoon.
Good afternoon. Ms. Nelson, if you could check with pretrial services and probation to see if they'll be plugging back in. We're a little after 2 and I had asked them to rejoin us.
Okay, I'll reach back out to them.
Thank you. All right, well, let's get on the record. We are back in 20 SC 176922, State versus Pritchett and Robinson. It is Thursday, May 2, a little after 2 in the afternoon, and we are here for sentencing. Several days ago, the jury came back with a verdict of guilty on most counts, not guilty on some counts, as to both Mr. Pritchett and Mr. Robinson. We have in court Mr. Hiles for the state, Ms. Mignot and Ms. Blake are here for Mr. Robinson, and Mr. Pritchett is here for himself. And I'm going to start with the state, as I should, and then we'll work our way around, and I'll hear from Ms. Mignot and Mr. Robinson if there's anything he wants to say on his behalf, and then we'll get to Mr. Pritchett. Mr. Hiles, you can structure your presentation in any way you want, and you should let me know if there are any of the victims who are going to be plugging in, or if you'll be saying anything on their behalf when you get to that. What I'd like you to do first, and then take it where you want, is share with everyone what merger, if any, you think happens with these different counts, so we know what's our universe of guilties that we're working through for purposes of sentencing.
Yes. So the mergers for the individuals that were convicted, for the victims, the counts were based off of armed robbery and ag assault, for which the victims or the jury found the defendants guilty on both of those counts, applying to each one. The ag assaults will merge.
So just as an example, count 9, which would be the aggravated assault of Mr. Carmody, would merge into count 2,
yes,
which is the armed robbery. I think he said Carmody, Mr. Carmody.
Yes, and then count, as in, yes, so count 9 merges with count 2.
I can figure that out, but you don't need to, I'll manage that part, but you agree, I agree, I'll hear from the other side in a minute, that the aggravated assaults would merge into the armed robberies of those situations where a defendant was found guilty of both. There are a few, all the ag assaults were guilties, but there were some armed robberies that weren't. There's no merger into a not guilty. So just taking Hooper as an example, that aggravated assault guilty, which would be count 15, is a 1 to 20. There's no sentence for count 3. Whoops, that's a bad example. Walker, count 4, not guilty armed robbery, but guilty ag assault, count 10. There's no merger to occur.
Correct.
Okay. Any other merger?
I don't believe there are.
Okay. Ms. Mignot, do you agree with Mr. Hiles's merger analysis?
I agree, Your Honor, that any ag assault that is also a conviction for the armed robbery would actually merge, and any that are not would not.
Okay. Mr. Pritchett, you and I haven't talked about merger much, but it's not procedurally proper for a defendant to be sentenced for 2 offenses that actually relate to the same overall conduct. The way the state charged the armed robberies, within the armed robbery was an aggravated assault. So if you were found guilty of both, the armed robbery, if you will, sort of consumes the aggravated assault, and it wouldn't be appropriate to sentence you on both those. If I did, it would just get sent back and say, don't give Mr. Pritchett a sentence for the aggravated assault. Do you have any disagreement with the analysis you've heard from the 2 lawyers? Okay. That's how I'll structure it. Mr. Hiles, your time.
Yes. So is it all right if I sit so I can speak into the microphone?
Yes.
Is it cool? Okay. So one thing before I get started on recommendations, there was a motion notwithstanding, or a motion for judgment notwithstanding the verdict that was filed.
Yes.
Alleging the state of prosecutorial misconduct as it applies to some of the slides that were in the state's closing PowerPoint.
So before you go any deeper into that, I'll be entering an order soon. There is no such thing as a motion JNOV in criminal cases. Procedurally, it doesn't exist. So I'll be filing an order that just dismisses it. It's all fodder, I think, appropriately for a motion for new trial. But I just didn't have time today to get to the order dismissing the motion JNOV, and it has nothing to do with the substance of it. So you don't need to push back on the substance of it. That might land in a motion for new trial, and then one of your colleagues can make whatever record he or she wants to make. But I don't want us to get into any of the substance of it because I'm dismissing the motion.
Okay. As it is, those slides are not part of the record.
Okay, but now you're getting into something that I just said I'm going to dismiss. So why don't we talk about?
Would you like me to do, now, would you like me to go through both Mr. Robinson and Mr. Pritchett and then allow them to go separate, or do you want to do each one individually?
I'd like you to share everything and anything about the two sentencings, and then I'll turn to Ms. Mignot, and she'll share with me what she wants and anyone who's here on Mr. Robinson's behalf, and then we'll do Mr. Pritchett. So you'll do both.
Okay. I'll start with Mr. Robinson since he's closest to me. In recommending his sentence recommendation, I'm going to cite to OCGA 1511-703, which is part of the juvenile code, which states that it is proper and the court should consider adjudications of delinquency in criminal cases for sentencing purposes. There are a few allowances as to when the court can use adjudications of delinquency, one of those being sentencing for criminal offenses. And that's OCGA 1511-703. He has quite a lengthy juvenile history.
How old was Mr. Robinson when the November 8th, 2019 conduct occurred?
November 8th, 2019, I believe he was 20 years old.
Okay. So he had a window of adulthood in which he got 0 convictions, but you're going to share with me some juvenile delinquency findings.
I am.
Okay.
So in 13 DL 05889, he was adjudicated delinquent for entering auto, possession of tools for commission of a crime. In 15 DL 02085, he was adjudicated delinquent for aggravated assault. In 15 DL 03492, he was adjudicated delinquent for false imprisonment and possession of a pistol by a minor and criminal damage to property in the 2nd degree. In 15 DL 05021, Mr. Robinson was adjudicated delinquent for robbery. In 15 DL 03542, Mr. Robinson was adjudicated delinquent for entering auto. In 16 DL 02599, Mr. Robinson was adjudicated delinquent for criminal trespass and disorderly conduct. And in 16 DL 03803, Mr. Robinson was adjudicated delinquent for aggravated battery and robbery. Your Honor, the aggregate sentence, and I'll go count by count, but the aggregate sentence that I'm asking for sentencing in Mr. Robinson's case is 35 years to serve, with the last 5 years being suspended on the possession of a firearm during the commission of a felony.
So not 40 to serve 35. It's really 35 to serve 30 with 5 suspended.
Yes.
Okay.
I'm asking on count 1, home invasion, 20 years to serve.
And share with me what you think the sentencing range is. You don't need to share with every armed robbery, but what do you think the sentencing range is for home invasion?
Home invasion is 10 to 20 years or life.
It's just like armed robbery.
Yes.
Okay.
Armed robbery is 10 to 20 years or life. Aggravated assault is 1 to 20. Aggravated battery is 1 to 20. Violation of street gang Terrorism and Prevention Act is 5 to 20. And possession of a firearm during the commission of a felony is 5 years consecutive.
Okay, thank you.
As to count 1, the state is requesting a sentence of 20 years to serve in custody. As to count 2, the state is armed robbery, Holden Carmody. The state is asking for 20 years to serve concurrent to count 1. As to count 3, armed robbery, the state is asking for 10 years to serve consecutive to count 2. As to count 6, armed robbery, Jackson Buckingham, the state is asking for 20 years to serve concurrent with count 1. As to count 7, the state is asking for 20 years to serve concurrent with count 1. Count 9, I believe, merges with count 2. As to count 10, the state is asking for 20 years to serve concurrent with count 1. Count 11, the state is asking for 20 years to serve concurrent with count 1. Count 12, I believe, merges with count 6. Count 13, I believe, merges with count 7. Count 14, the state is asking for 20 years to serve concurrent with count 1. Count 15, I believe, merges with count 3. Count 16, the state is asking for 20 years to serve concurrent with count 1. Count 18, the state is asking for 20 years to serve concurrent with count 1. As for count 19, possession of a firearm during the commission of a felony, the state is asking for 5 years to serve suspended, which would be run consecutive to count number 3. Your Honor, the basis for this sentence is, I do understand that the nature of the juvenile offenses, that he was a juvenile at the time. However, there are several that are incredibly violent that he was adjudicated delinquent for. And though there might have been 3 years in between his last adjudication of delinquency and the commission of this crime was incredibly violent. It was not just a go into the house, show a gun, and give me your possessions. 2 people.
Which in and of itself is bad enough. You say it's not just go into a house and show a gun. I mean, that already is really serious and bad and dangerous.
No, I am.
Yeah.
It's terrible.
Yeah.
It is absolutely terrible. But the injuries sustained to Vic Gattani were terrible. He had a fractured skull, severe lacerations. There was months that he spent where he wasn't sure if he was going to be able to drive again or walk without a cane because of the vertigo that he was experiencing. And not to mention, all of the victims testified as to the traumatic effect that this had on them, not only having the guns in their face, but watching their friend be mercilessly beat as he was begging for mercy and seemingly complying with all aspects of this particular crime. I think that the 30-year sentence on those charges is fair and appropriate, given the age of the defendant in the violent nature of the charges, the traumatic experience left on the victims who all testified to the PTSD involved, as well as in combination with the pattern of violence even in his juvenile years. So that is what the state is asking for as it pertains to defendant Tyrone Robinson. Now, moving on to defendant Maxx Pritchett, the state is asking for a total sentence of 45 years to serve all of that service being incarcerated. And the state is requesting the breakdown in this nature. Count 1, home invasion in the first degree. The state is requesting 20 years to serve. Count 2, armed robbery of Carmody. The state is requesting 20 years to serve concurrent with count 1. Count 3, armed robbery victim Hooper. The state is asking for 20 years to serve consecutive to count 2. Count 6, armed robbery of Buckingham. The state is asking for 20 years to serve concurrent to count 1. Count 7, the state is asking for 20 years to serve concurrent to count 1. Count 9, again, merges with count 2. Count 10, the state is asking for 20 years to serve concurrent with count 1. Count 11, the state is asking for 20 years to serve concurrent with count 1. Count 12, I believe, merges with count 6. Count 13, I believe, merges with count 7. Count 14, the state is asking for 20 years to serve concurrent with count 1. I believe count 15 will merge with count 3. As to count 16, the state is asking for 20 years to serve concurrent with count 1. Count 18, the state is asking for 20 years to serve concurrent with count 1. Count 19, possession of a firearm during the commission of a felony. The state is asking for 5 years to serve consecutive to count 3. And as to count 20, possession of a firearm by a first offender probationer, the state is asking for 5 years to serve concurrent with count 1. Your Honor, the same aggravating circumstances of the violent nature of this home invasion that I just described as in recommending the sentence to Tyrone Robinson. I will just reiterate those instead of going into them again, but I feel like they apply equal in nature, if not more, to Mr. Pritchett. Additionally, Mr. Pritchett was given a chance, and it wasn't brought up in front of the jury, but he was given a chance after it was a burglary, but it was a home invasion style burglary. There was no weapon used, but the door was kicked in to a man who was at home and in fear for his life.
Is that why this may have occurred before your time, but that was charged as a burglary plus felony murder because there was no deadly weapon in the mix? I mean, they couldn't have used anything on Mr. Greer because he had already jumped to his death. But the cooperators didn't say we all had sledgehammers or knives or guns.
Yes, because the death occurred during the burglary. It was a simultaneous thing, and he was trying to climb and or jump. It's unknown, but that happened as the defendants in that case had breached the door.
I didn't ask the question well. I understand the felony murder piece. I'm curious why it was charged as burglary and not home invasion. Was it because there was no evidence that they had deadly weapons on them?
That is correct. There was no evidence of deadly weapons. There was none from the surveillance, but yes, that's why it was charged as burglary. Correct. But nonetheless, he was part of the planning. He got all of the discovery. There are part of the record in this case as to even the Ferretta hearings. There have been jail calls entered where into the record of this case as to Mr. Pritchett acknowledging the receipt of my 418 motion, stating that it's based off of the discovery that they had already received and gone through in the death of Jose Greer. That is a huge, huge break to be getting a second chance. He was given a second chance. And I was debating whether or not to ask for life in this case. Which maybe he would have been eligible at some point for parole, but that would have been no guarantee. But I do think the 45 years to serve, considering the fact that he was charged with murder beforehand and not 9 months after being released from custody on that case, is involved in an incredibly violent home invasion. Not to mention convicted of doing so in furtherance of the Young Slime Life gang, which I guess would also apply to my sentence recommendation for Robinson as well. But those are that is the reasoning of the state and the recommendations of the state, and I would just ask that the court follow the state's recommendations.
Two things. One, from your review of Mr. Robinson's juvenile history, were there any gang-related aspects to any of those delinquency findings? Or that's just, you can't tell from looking at the dispositions?
I cannot tell if there was any gang-related, and the only thing I do know is I did not see any gang allegations in those records, but I cannot say as to the facts of each case.
Have you seen that before, that in juvenile court, they'll tack on a street gang terrorism and prevention act allegation to a juvenile?
I have seen that, and there's a massive push and pull between the state and juvenile judges as to whether that it's a point of contention.
Sure. What does it mean to be a knowing and active member when you're 13? We even understand what it is you're doing. Not that he was 13 at the time, but I can understand why there would be a policy debate between the judges and the prosecutors. Okay. My other question was, is there any victim impact, anything from anyone beyond what we heard at trial?
There's nothing. No, only that each one of them reiterates that they are.
We would object if the victims, it's my understanding, if the victims did not appear, the court cannot hear victim impact statement from the state.
Can.
Okay. I have a different understanding, so you can keep going.
So, no, just reiterating the traumatic experience that several of them, even if they weren't physically injured, spent years getting over it, if not still dealing with the traumatic experience. It was a lot just for them, some of them, to testify. And they wanted me to reiterate that they even pushed back on me against testifying because they didn't want to relive the experience. Outside of that, it is.
Or get cross-examined about the lines of work they were in, but I understand that.
Yes.
It was not easy for anyone. Okay. I very much appreciate your presentation, and I can understand why some of them aren't here. They don't live in Atlanta, and others are. They're relieved to have maybe closed the book on this. Okay. Thank you. Let me see before I pivot to Ms. Mignot. If we do, Ms. Roberts, good afternoon. I have two questions for you. Criminal history information, if any, on Robinson, that's number one, and Pritchett, that's number two.
Good afternoon.
Hey there.
Robinson does not have any felony convictions listed on his GCRC, and I'm showing 2 cycles. And Pritchett, I am showing a total of 4 cycles, 2 out of Georgia, 1 out of Texas, and 1 out of New York. Also, I do not see any felony convictions listed for Pritchett.
What was the Texas cycle?
2017 for possession of marijuana less than 2 ounces and possession of a controlled substance, Schedule 2. Looks like that case was dismissed December 21st, 2018.
Okay, and the New York, I think I know, but what does it say in the NCIC?
April of 2016,
Oh.
officer fails to bring person arrested on extradition warrant to court.
Okay.
The disposition was not arraigned.
Okay. Thank you so much.
You're welcome.
Ms. Mignot.
And Your Honor, is there a preference by the court if I have a family member speak on behalf of Mr. Robinson prior to getting into the law and asking the court for its sentence?
Any order you want to do it. This is your presentation, so I will respect your approach.
Thank you, Your Honor.
Sure.
At this time, we call Ms. Robinson.
Okay.
May we have her stand here?
Yeah, ma'am, if you don't mind coming up to the podium, that way the court reporter will be able to hear you.
Good afternoon, Your Honor.
Good afternoon. And if you could state your name for the record so the court reporter knows whose word she's taken down.
Pritchett Robinson,
Can you spell your first name?
Catherine.
Okay. When you're ready.
I would just thank you for the opportunity for me to speak on behalf of my son.
Sure.
I would like to start off as Tyrone was born 9/10/1999. When Tyrone was placed in daycare, I used to get these phone calls saying, Tyrone hiding up under the toilets. And I was like, what's wrong with him? I have to take out work, go see what's going on with Tyrone. So I decided to take Tyrone down to Hugh Spalding and have him checked out. And they say, Tyrone, okay. I take him back to school. Something going on with Tyrone again. I take him back down there to Hugh Spalding again. Tyrone, okay. As he got older, it kept going on and on and on.
The going on isn't that he's getting in trouble, it's that he's kind of hiding somewhere?
His mental.
Okay.
So as he got older, it was going on and on and on. So they say the state is the help. I called defects on myself, trying to get myself some help. Defects came out to my home. They said, I have food in my home, no bruises on my kids, open, closed case. As he was going to school, middle school, Tyrone he's doing his work, but he keeps shutting down on this, crying out for no reason. He won't tell us why he crying. I go to school, take out work, go up to the school. Tyrone, why you crying? What's wrong? I don't know, mama. Something in my mind just telling me to cry. I'd be like, baby, stop crying. It's okay. Take him home with me. Tyrone, why you crying? I have had Tyrone in numerous mental health facilities. I have had him put in youth village, this mediologist home. I mean, Tyrone been placed in numerous mental facilities. He been on numerous medication.
What do the doctors there tell you? You're now going to folks who can die. It's not Hugh Spalding saying,
Right.
"No bruises, he's okay," or DFAC saying, you're a great mom, household is safe. You've now got mental health professionals spending time with your son. What do they tell you their concern or diagnosis is?
Depression, ADHD. It been so many of them. I have them listed.
Did he get medication for those?
Yes, he was on a lot of medication. So, like I said, Tyrone always been a smart kid. The charges that Mr. Hall is bringing up on the armed robbery charges, he was with another kid that committed those crimes. Tyrone was never convicted of those crimes. And the guy came to court and forgave Tyrone for those charges. That was the only way to get the proper help for Tyrone. He helped me get Tyrone into this program where the state, he was in the state custody, but he was in state custody, but still in my home. So they'll come out to the home, make sure Tyrone took his meds. I proved to them that he took his meds, and I did make sure Tyrone stood at the bus stop and got his GED. So he do have his GED, but Tyrone is a good kid. I have 3 kids. I have a 27-year-old. She just got done with college. I have a 16-year-old. She's a junior in high school. She plays soccer. She's in JROTC.
Where does she go to high school?
South Atlanta High.
Great.
Tyrone is a good kid. He have a lot of mental issues that never been addressed the proper way.
When your son was taking the medication that the doctors prescribed, did that seem to you to help? That he would be, he'd get upset less often?
Some of them helped and some of them didn't help. Some of them used to make him too drowsy to where he can't do anything. Some of them made him think a little negative, but he didn't do negative. He used to hide himself up under the sofa, behind the toilets, but he's never did anything negative. So as a parent, Your Honor, like I said, the state have failed me terribly. I called defects on myself twice for help with Tyrone. So as a mother, Your Honor, I'm just asking you, before you sentence my son, I'm begging you to give him a second chance. Let's help Tyrone and get Tyrone in the right programs that's gonna help him before we destroy his life.
Okay. I appreciate you sharing that. There's always much more context to every individual than
I
what
mean, I
we see
have
in this.
several records of Tyrone being in different facilities of just me trying to help him. The state never tried to help me. I always beg the state for help. They come into your home and say, you got food in your house, kids got clothes, they got beds, no bruises, open closed case.
Okay. Well, I want to be clear. It sounds like you took all the steps you could to provide for your son.
Mhm.
There were clearly times when he was far outside your supervision, and he reached the age where it was okay for him to be outside your supervision. And whether it's due in part to some of the mental health issues he was struggling with.
He have a lot of mental health issues. He was diagnosed with ADHD, depression. He was on borderline with autism. Tyrone suffered with a lot of mental health issues. He have tried to commit suicide on numerous occasions, which I have got phone calls saying that he on try to commit suicide while he's been incarcerated. I just ask that we help Tyrone before we mess up Tyrone's life.
Okay. I appreciate you sharing that. Thank you. And I appreciate you being here throughout the trial. He had someone for him, and we don't always see that. And that's even more depressing when there's a young defendant. He's got his lawyer, but there isn't family there for him. So thank you for that.
Thank you, Young.
All right. Ms. Mignot.
Thank you, Your Honor. May it please the court, on behalf of my client and his entire family, I have to say that it is an honor to do my duties as an advocate on behalf of sometimes people who are the forgotten, lost. And unfortunately, it's not until we get in a situation like this that people like me have an opportunity to try to address the honorable court on behalf of what I think is going to benefit not just my client, but society as a whole. If we are honest with ourselves, we know that people like Ms. Robinson and her son exist. And no matter the efforts that they make to try to get the needs of the child addressed, that unfortunately sometimes delay is denial. And the child gets to an age where the parent is being told by authorities, unless you have some type of court order stating that you can speak on behalf of this individual, we're not going to hear anything from you. So as it pertains to my client, Your Honor, at the time of this incident, he was 19 years of age. And unfortunately for him, I was approximately lawyer number 3 or 4.
At least 3.
At least 3, Judge, on the roster. And by the time we got involved in this case, a lot of time had passed. And there was a lot that we could not lawfully do to catch up or fix because certain deadlines have been passed. So I submit to the court that my interactions with Mr. Robinson, he does need help. And the first thing I'm going to ask the court for in this situation, although it may seem like I shouldn't be asking for it, will be some type of probated sentence that's going to help him to be evaluated and treated. Because I think if we get him evaluated and treated, we can stop what our system wants to stop, and that's recidivism. This court, I am preaching to the choir, is involved in drug court, is involved in mental health court, is involved in rehabilitative efforts in this county to try to make sure that individuals such as my client get an opportunity to treat what the underlying issue is and be able to become a productive citizen in society. I submit to this court my interactions with this young man, he can get the help. And if he gets the help, he's going to become a productive citizen. He has never been anything but respectful in his interactions with me. He has never been anything but polite in his interactions with me. And his story breaks my heart, not just as an attorney, but as a mother, because I know that if Tyrone Robinson had gotten the assistance he needed as it pertains to the signs and the underlying medical issues he had, that we probably wouldn't even be having this conversation. Your Honor, his record is extensive, and unfortunately, I could not file some of the things that I would have filed had I gotten in this case earlier. But there's mention of autism spectrum in the records. There's mention of bipolar disorder. There's mention of schizophrenia. There's mention of a lot of mental health, and his history goes way back to youthful, prior to his juvenile cases that the state want to allege. And I submit to the court that even though he has those scrapes with the system, no one made sure that there was follow-up associated with it. As it pertains to the one that the state mentioned that the state believes is a aggravated assault offense, my client was sexually assaulted in that situation, and no one protected him from the sexual assault. And that case requires him to defend himself. So the facts, if the court is to look behind the veil of just a charge and get to the facts of what was going on as it pertains to that situation, the adult in that situation would have been dealt with prior to my client having to deal with the adult themselves. I get to the sentencing in this case, and I submit to the court that as it pertains to what happened to these victims, and I don't want to discount that, what happened to these victims, Your Honor, is real. It is real, it is traumatic, and I don't want to discount that. But I'm asking this court to look at the totality of the circumstances surrounding this case, including but not limited to some of the evidence that was surprising to me, that some of the alleged victims took a flight and went straight to a Travis Scott rap concert the morning of the same incident that the state is professing was so traumatic for them that they can't talk about it. I know everybody is traumatized by court, so I'm not discounting the fact that having to come here and testify and all those things are not traumatic for alleged victims in this case. Mr. Gattani, I am sympathetic. A scar is going to stay with him, according to the allegations in this case, for the rest of his life. I totally understand that, Your Honor. But as it pertains to the evidence in this case, which the court heard, I submit to this court that I still believe that there are some issues associated with the evidence in this case. But we are not here for that today. Right. We are here for sentencing. So as it pertains to the counts that have not merged, I have come up with what I believe is the resolution that the court would be able to address all the issues at the same time. As it pertains to the home invasion, Your Honor, we would be asking this court, because the sentence minimum is 10 to 20, to sentence Mr. Robinson to the minimum sentence of 10 to serve 5, credit for time served, because he has been in custody since his arrest. His bond, I believe, is at $1 million. He couldn't make it, even if he tried. And he has served. He's going to be here. I believe he got into custody. It was December, if not the 6th, the 9th of 2019. And he has been in custody since then. So we'd be asking the court to give him credit for time served on the home invasion. As it pertains, Your Honor, to any of the counts that did not merge on the possession of a firearm, that sentence be a 5-year probated sentence, because that probated sentence is going to give the court the power to order the evaluation, mental health evaluations and treatments and follow-ups that Mr. Robinson is going to need, assistance with employment, housing, all those things that he is going to need help with. And that is the sentence that I am most important with, because it's a consecutive too. The statute requires it to be a consecutive sentence. As it pertains to the aggravated battery counts, we're asking the court to sentence Mr. Robinson to 5 years credit for time served and run all of them concurrent. As it pertains to the aggravated assault, we're asking the court to sentence him to 5 years time served for the time that he's been in custody. And once again, Your Honor, as it pertains to any of the other sentences, as it pertains to the armed robbery, I'm sorry, those are the only counts that I have not addressed as yet. The armed robbery counts, we're asking the court to sentence to the minimum of 10 years. And pursuant to Jackson v. State, which is 338 Georgia App 509, this court has the ability and the legal ability to consider deviation. And we would ask the court to consider deviation as it pertains to that sentence and to sentence Mr. Robinson to a time served on those counts also. Your Honor, the most important thing for us as it pertains to this court sentence is the mental health evaluation, treatment, and assistance that Mr. Robinson did not get the first time he interacted with the judicial system. We thank you, Your Honor, for your grace and your mercy as you pronounce sentence upon our client associated with this case.
I have a question for you that predates your involvement by many years. But I'm curious if in working with your client, his mother, you got a sense as to how or why Mr. Robinson wasn't connected with mental health resources through juvenile court. I understand the DFAC story and going to Hugh Spalding, but what I understand and have experienced with juvenile court is that they're very focused on the needs of the child. And it would surprise me to learn that in no instance were there steps taken to connect Mr. Robinson with the appropriate resources. I know that predates you, and I'm not wanting to hear anything privileged.
Right.
But that little piece is missing for me, is how he clearly was well known down at juvenile court, and a track record like this is exactly the kind of track record that would prompt the judges and the entire social services support network there to say, what can we figure out to try to bend this curve in a different direction?
I did look into the records, Judge, and it was mind-boggling to me because I couldn't connect any dots to, and you are hereby ordered to the services of.
Yeah.
So he might have just been one of the many cases that they were dealing with at the time that just slipped through the cracks. And unfortunately, time moves faster than we anticipate. So once you hit that 17, 18 mark, nobody's looking at you anymore and juvenile cases are closed. Goodbye, good luck.
Yeah.
I did try to look into that, Judge, and I can assure you that the records that I looked at, which were extensive, didn't include any follow-up. And that's why today it was most important for me to focus on him getting assistance. My concern is that state prison is not going to get him any assistance. And unfortunately, because of how the state prisons are run across this country, that what you do is go to state prison to learn how to be a better criminal. So when you come out, you are guaranteed recidivism. They might as well give you a diploma in crime because that's pretty much what you're going to learn. Because we're not focused on rehabilitation, we're focused on incarceration. So you sit there, and then we let you out on society and hope that somehow psychologically something clicked on and the light bulb went on. And if I had cancer, Judge, and you lock me up, it's not going to cure my cancer. So I am begging this court to do something which I know this court has the ability to do and is willing to do based on your history, your resume, and what I've looked at that you've done. He couldn't ask for a better judge to be before as it pertains to making sure he gets the help he needs so that he can become a productive citizen.
All right.
So thank you again, Judge.
You bet.
For
Thank
allowing
you.
us to address the court.
Yes, ma'am.
When Tyrone was committed to the.
Can you come up? The court reporter needs to be able to hear you. Thanks.
When Tyrone was committed to the state, was still in my custody at the age of 19, I still didn't get no help. The only thing his probation officer did was make sure she came out to my home to make sure he was in the house. Anything else was on me. Making sure he get to counseling or get the proper help, medication, everything was on me. They was only doing paperwork. Everything was still on me. The state didn't help me. The state failed me as a mom with Tyrone.
All right. I'm sorry to hear that, but thank you for adding that.
Mm-hmm.
Oh, I didn't know that his sister would arrive, Your Honor, but she is present. If you'll just stand up in support of Mr. Robinson, his sister has arrived, Your Honor.
Thank you for being here. All right, Mr. Pritchett, it is your, before we get there, Mr. Robinson, you have a right to, we call it allocute, say anything you want. You don't have to say anything at all. It's sort of like whether you choose to testify. And you've had a very eloquent speaker too on your behalf, your mother and your lawyer. But I'd be making a mistake if I didn't give you the opportunity to say anything you want, or nothing at all. But I need you to say on the record, I don't have anything to say, or whatever it is you want me to know.
I don't have anything to say, Your Honor.
Okay, thank you. Mr. Pritchett, you are up, and I'm going to need you to come up to the podium because you don't have a microphone at your table. Thank you. Good afternoon, sir. What do you want me to know? And do you have anyone who you have to speak on your behalf?
I believe one of my family members that are here today, my father,
Okay.
he would like to speak on my behalf.
Do you want that to happen first, or are there things you want to say first? You control the order in which we do these things.
That can happen first.
Okay, sir, if you'd come on up. And Mr. Pritchett, if you just sort of slide over there. Thank you. Good afternoon, sir.
Good afternoon, Your Honor.
Could you please state your name for
I
the...
am Pastor Dominion, and without further ado, I want to thank you for this moment and opportunity.
I need your name for the record.
Oh, yes, Prentice Dominion.
All right, Pastor Dominion.
Yes, sir. Okay. I want to ultimately, bottom line, I want to just share a little history in Atlanta that I have personally, number one, saw with this landscape. Number one, I've served with two of the administrations here, from Kasim Reed and also with Ms. Bottoms, in regarding to my ministry, which is totally humble under God, which is, Your Honor, thug ministry, totally humble under God. And what we saw in these last few years, as you see in the other court and this court, if you look at the landscape, you'll be able to see, number one, in this case here, we saw, I'm not going to say youth or young adults, all ethnicities. And what we saw was drugs, robbery, music. What I've seen so much and what I've been able to assist with, I've seen a lot of these things, of course, bottom line, stimulate from this music that we have right now. Of course, my son, of course, I've sent him off to Morehouse. Very astute, a great student. One thing I've experienced in this lifetime that I see right now that's happening, we deal with an issue, but of course, there's an underlining. And the underlining, there's also a spiritual component that has to be dealt with. The Bible tells us, of course, to guard our heart with all diligence. And one of the things I noticed that we are seeing right now here in Atlanta and across these states is that we are seeing, number one, the music being a great culprit that's allowing virus in these kids' hearts. And we're seeing kids being affected. One thing I do know, there needs to be a change because we are being challenged as the courts, those who in law enforcement, we're seeing a challenge that right now that's getting completely out of hand. I studied a child who for 3 hours a day, 5 days a week, listening to rap music. Number one, we see their hard drive infected. If you're listening to, I smoke weed, I do drugs, I do this, 3 hours a day, 5 hours a week. The real culprit that I see is not here on trial today. That's the Sonys and the EMI and the Arista Records that are paying these guys $1 million to $2 million just to be exploited. And we found ourselves landed here because we have kids who are not guarding their hearts, but are listening to these music. And ultimately, we see them now with virus on their hard drive. And you and I both know When your hard drive has a virus, what happens? We click and it takes us somewhere else. I send my kid to Morehouse, clicks, it takes him somewhere else. But of course, one of the things that I experienced also, he had a love for music and I thought he was going to be successful in music. And I see this challenge right now. I've had the opportunity to experience, I'm going to say, a nightmare. On the streets of Atlanta, another child who was in music. In 2017, Your Honor, he lost his life. Supposedly to the world, a great rapper, but again, he lost his life in the streets. So what I've seen also as well, I've seen my son Maxx also be greatly affected by this, the family affected by this. I believe ultimately if we're going to turn this around, it has to be a spiritual component, a spiritual answer as well to the plights of these youth who are coming before you every day. As we've seen with the landscape here, what are we going to do about the individuals that left here and that we would know they were involved with drugs or into rap music? And then of course, we have another group here charged with a crime of a home invasion. Neither one of them works for the community. Neither one of those situations are something that we want to actually, bottom line, feel that's going to be great for the community. How do we change this? I believe it has to be a component to where we all come in an agreement that we must invite the Lord in this. Now, my son, I want to say, I know this is a terrible situation. But him himself personally, I'm going to say is a great kid, knowledgeable. I brought him up in the Lord. This is kind of hard for me right now. There's a level of trembling right now because I know the effects are grand. But I know we serve a great God. But even right now, I've heard all the numbers. I've heard the state's suggestion. I asked the court that we put in consideration the complete landscape. What is the complete landscape? Maxx comes from a family who serves the Lord, serves the community. I'm going to say grew up in the Lord, grew up at the altar. What I do want to say is he's had a tremendous amount of experiences in his life in these last 15 years. Tremendous. What do we do as a parent? What do we do as a parent? We pray and we believe and we trust God that we will never end up in these situations like this. What am I asking the court? The same thing I'm asking the Lord. Justice, of course, but I'm asking for mercy. I believe right now, without a shadow of doubt, with a chance, by faith, not only can he be a productive, law-abiding citizen, I believe he'll have an opportunity to become who God has ordained him to be, a man of God. With all that being said, I do know, Your Honor, this is not something that, again, you do hope that we're going to be able to rid this problem that we're seeing happening on the streets right now. The guns and the murder and the music and et cetera. But how do we bring that change? How do we bring that change? I believe that change comes your job, and I believe there's a spiritual component, me continually preaching the gospel and the good news of Jesus Christ, that ultimately is going to change someone's heart. And I believe that right now is a great opportunity right now for the mercy of God, even right now, as I share my son's plight. And I believe overall, it's kind of tough, but I do want to say, I believe overall, you're going to see a changed citizen with another chance. I do believe. So I ask by the power of God that you just, as you make a decision, I hope and pray that the court would have mercy. And even right now, I pray that you even give Maxx an opportunity to move forward. In Jesus' name, amen. Amen.
Thank you, Pastor Dominion. And thank you for the work that you do outside this courtroom. Mr. Pritchett, if you'd come back up, please.
I think his sister wanted to speak, Judge.
Oh, okay. Good afternoon, ma'am.
Good afternoon.
Could I have your name, please?
Sarah Pritchett,
First name is spelled,
S-A-R-A-H.
all right, Ms. Pritchett?
Good afternoon. As you know, I've been at every court date with my brother, Maxx Pritchett.
At least every court date.
Yes, I've been by his side, and it has been a long journey, and I know that some difficult decisions have to be made. And ultimately, I just want to let you know who he is to me. Maxx Pritchett is my brother. We grew up in the house where it's just us. We're very close knit, come from a great family. We're like 2 years apart, and we grew up in the church. We have always got along. It has never been any, as far as he has never had any trouble growing up or in his like past life to where things have been crazy. Me and my brother have suffered through a tragedy when we lost our older brother. And I'm really asking if you can have mercy on my brother, because I already lost one brother to gun violence, and I don't want to lose another brother to the system. And with the faith that I have in God, I know that he will never be lost, because it's always hope. So I'm just basically asking if you can have mercy with him, because Maxx is a great person. He has always been, he has taught me so much in life. I'm who I am today because of my brother. He's my hero. He's my best friend. And Maxx, he's not a gangbanger. He's not in a gang. He has never been. And I really want to make that record known. Maxx is not a thug. He's never been a member of a gang at all. Never has been. And as long as I've known Maxx, he's a good kid. He's smart. He's great in basketball. Grew up academically smart, and he's just a great person overall. And I just want the court to consider in what you give him, because I know that the prison system is not ordained to grow a person mentally, spiritually, and I've seen nothing good come from that. So with another chance, I will believe that he will be the God-ordained person that God wants him to be, and still be able to live a life according to the law, of course, and the word of God. So I'm just basically asking you to just consider just a different take on what the state is trying to give them. Thank you.
You're welcome. Mr. Pritchett.
How do we go about this?
You say whatever you want to say. This is your chance. It's a little different from Mr. Robinson because you're your own advocate. And so you don't have to say anything at all. This is your time to allocute, to say, here's what I think you should do, and here's why. But you're not under any obligation to say anything. I've now heard from your father and your sister, providing an important other view into your life, because obviously what I heard during the trial isn't your best side. But your father and your sister have helped me understand what I knew to be the case, that everyone is multifaceted, and it is rare for someone's sister to come in and say, I hate my brother, you should lock him up for 1,000 years, unless she was the victim of the crime. And that's not her role in this. If there are things you want to share, now is the time, but you don't have to do anything.
One one scripture that comes to mind is in James. And it's that mercy triumphs over judgment. And I believe, God, according to his word, desires repentance over punishment. And I believe in this day and age, 2024, we do have to look at reality for what it is. And the prison system doesn't save. But I do believe that every life is worth saving, including mine. But again, everybody's life is worth saving. And I say that to say that state's recommendation of that time is not saving my life, but it is more. It is definitely more destroying it. And I just firmly believe that even over the course of these 4.5, 5 years that I have already been incarcerated, it wasn't the bad conditions that I'm surrounded by. It wasn't the stabbing and the suicidal that I'm surrounded by. It was none of these things that caused me to look, at myself and create a deeper change within me. It was none of those things that caused me to do that. It was, I believe it was me crying out and searching for God himself that really caused me to do it. I'm not sure exactly why. It took this for me to really search and cry out for God in a genuine, full-hearted, wholehearted way. But I know sometimes it does take those drastic measures for a person to really, build that relationship with God and their creator, which I believe is everyone's duty on this earth. And everyone's duty is also to fear God and follow his commandments. And again, I believe that, like I said, over these past 5 years, I have raised my standard of just morale and value and knowledge. Because the word repentance, it actually means, when you break it down, it means to gain a new understanding and to gain new knowledge. And I believe I've gained a new level of these things to really allow me to be aware, fully aware of the decisions that I make. And this is an awareness that I was lacking previously, of course, but over these past 5 years, I believe that there's been just in me a new level of change, a new level of virtue and standard of just morale again that I've reached, and going to prison for the rest of my life would put me in fear of just, degrading myself back down to a level that I never want to go back to again. I only want to get closer to God. I don't want to stray from him. And I believe that just being in prison again for the rest of my life will put me in danger of really straying and going away from God. And so again, I am asking for the court to allow its mercy to try and triumph over his judgment. To also take into account that I do already have a 20-year sentence. And acknowledging that, I would ask the court for 20 years in concurring with the sentence I already have. But of course, in asking that, I would also just ask them to, and it may be hard, but I would also ask them to believe that within that time period, there will be a level of elevation spiritually and mentally that I will achieve, to where, again, I won't stray from the commandments. I won't stray from God. Every life is worth saving, and I believe right now with the request, I'm imposing a method that this court can possibly save my life rather than destroy it. I believe the plan imposed by the state is just destroying my life, and And again, every life is worth saving. And it wasn't, like I said, it wasn't the conditions or the environment I've been in, you know, in prison and in jail these years that it caused me to, you know, look within myself. It was the Spirit of God Himself that caused me to do that. And I don't want to lose that. I don't want to be in a position where I lose that, you know, ability to elevate. And so, yes, I just ask for grace and mercy. That's it.
All right. Thank you, Mr. Pritchett.
One more question. If there was a motion I wanted to file, could I do that today?
I'm going to talk about your ability to file motions and appeals and all that, both for you, excuse me, as well as Mr. Robinson. So I always prefer salvation over punishment. This is the worst part of the job of being a judge. I have excellent advocates in front of me that are pulling not in entirely different directions. No one's saying let everyone out right now and rejoice their sentence is over. But I wanted to be clear that part of what necessarily flows from a jury finding defendants guilty of multiple armed robberies and aggravated assaults where people were left praying for their lives, seeing their lives flash before them, not sure whether they'd live to see the next day, are pretty meaningful consequences. This case is very different from a shoplifting or an entering auto. There are 7 people who will never forget what happened to them, and what happened to them was in no way a good thing. And that is what drives this, not some refusal on my part or the system's part to appreciate that the lives of those who were accused and convicted in this case were complicated leading up to these events. Mr. Robinson, I'm going to start with you. I appreciate from hearing from your mother and from Ms. Mignot that many of the early years of your life, you were underserved by the community. You had needs that were not met, and they weren't unrealistic needs. They were important needs. But I also got to see a side of you that was smart and coherent and communicative when you were interacting with people, texting, some of the videos. And by that, I don't mean you had a gun in your hand or not. That's not my point at all. It was seeing you interact with people and seeing you behave in a way that tells me that while you might not necessarily have appreciated how risky some of the things you were doing were, you were very much in control of yourself and your faculties and choosing to be a part of the actions and the activities that we saw you involved with. And so as I hear from your mother about how you've had struggles, I also see from the evidence someone who was aware of the dangerous nature of what he was going to do, but went forward with it anyway. And while I would like to connect you with the appropriate resources as soon as I can, it is, I believe, necessary and appropriate from a justice perspective that there be a period of time beyond the years you've been waiting for this disposition that is punishment for what happened. And this applies equally to you and Mr. Pritchett. You may feel very, very unlucky right now, but it was truly luck and chance that no one died that night. It was a random fact that no one in that house had a gun. Because if anyone there had a gun, legally or not, they reached for a gun. You guys have guns. Doesn't matter if your guns were real or not. Someone was going to get shot that night. And it may have been that this case was about Tyrone Robinson having been killed during a home invasion. And what do we do with the person who shot him? And the law is a confusing thing. Mr. Pritchett could have been prosecuted for felony murder for your death if you had been shot by one of the occupants of that house. And then we're talking about a dead body. That's how dangerous this situation was. And so there just by the grace of God, we're not dealing with dead bodies, whether it's yours or Mr. Pritchett's or any of the people in the house, should they have chosen to resist, or who knows, Mr. Gattani might not have survived getting smashed in the head. He did, and we're all grateful for that. That's just me emphasizing how serious this situation is. Your sentence, Mr. Robinson, as to count 1 is 17 years to serve. Count 2 and 3 are also 17 years to serve. 6 and 7 are 17 years to serve. The counts I skipped were not guilty, so there's no sentence there. Count 9 merges into 2, no sentence there. And all those sentences I just mentioned, the 17 years to serve, all run concurrently with each other. Counts 10 and 11 are 18 years to serve. They run consecutive to count 1. Count 12 merges into 6, 13 merges into 7, 14 is 18 years to serve, concurrent. Oh, I did the math wrong. It's eight years on all those. I apologize. So 10, 11, and 14 are 8 years to serve. They run concurrently with each other, but consecutive to count 1. Count 15 merges into count 3. Count 16 is 8 years to serve. That runs consecutive to count 1. Count 18 is 5 years to serve, concurrent with count 1. And count 19 has to be 5 years, and it has to run consecutive to count 10. And that yields a total sentence of 30 years to serve 25. And you get credit for the 5 years you've served. And your lawyer can talk to you about the years that are parolable versus non-parolable, but I structured that purposefully in that way. When you are on probation, or if you are paroled, I will recommend that the Department of Community Supervision assign to you a mental health officer. And I will make it a condition of your probation that you submit to a mental health evaluation and treatment. I will also recommend to the Department of Corrections. I can't tell them what to do. I can encourage them to do certain things, but I will encourage them. They'll do this anyway, I believe. That's what I've been told, but I'm going to recommend it anyway, that they run you through the normal battery of tests to see if there's certain treatment you need and if there's a facility where you should be housed to get you the best chance of getting the treatment and care that you need while you're in custody. I'm going to talk to both of you about your appellate rights in a minute, but I want to pivot to Mr. Pritchett. Mr. Pritchett, you and your father and your sister all asked for mercy. Mercy certainly flows most readily to those who showed mercy themselves. And I'll tell you, the part that I struggle with the most is that within a few months of you being involved, and I'll agree with you, it was involved very peripherally with the first home invasion burglary in which someone died, you were back in the mix. I appreciate that you were younger, but what I have heard from your father and your sister is that, unlike Mr. Robinson, you were blessed with a situation, a childhood where you weren't struggling with mental health challenges, got to college, and were afforded any number of opportunities. I wouldn't be surprised if you tested off the charts with IQ. You strike me as an exceedingly intelligent person. I watched you absorb the way the lawyers were doing what they did in court, and you fairly quickly were able to do the same. And so I'm left puzzled at how you ended up doing the things that you did, because they are very, very inconsistent with what your sister experienced. And while she called you her hero, I'm confident you're not her hero as the Jose Greer case, or by being involved in this case and what you did on November 8th. But as I said, everyone is a composite of things. And I think that you've let your family down by not once, but twice getting involved with real dangerous, violent criminal activity. I'm not sure how to eliminate the virus from Mr. Pritchett's hard drive. One would think that losing his brother to gun violence might do it. One would hope that if that didn't, then the mercy that Judge Dempsey showed would have had an impact. But that was one persistent virus, because just a few months after getting out from Judge Dempsey's merciful second chance sentence, this happened. And I think I would be remiss and be underserving society if I said, well, let's have a third chance and get you right back out. You may have grown up at the altar, but you have strayed very far from it. And I'm happy for you if you have refound a spiritual way of life, and you are a charismatic person. Change starts with you, but you may be able to affect change on others while you are in custody. I hope you find that within you. Your sentence, Mr. Pritchett, as to count 1 is 20 years to serve. Counts 2 and 3 are 20 years to serve. They run concurrently with count 1. Counts 6 and 7 are 20 years to serve. They run concurrently with count 1. There's no sentence for counts 4, 5, or 8. You were found not guilty. Count 9 merges into count 2. Your sentence as to count 10 is $15 years to serve 10. That runs consecutive to count 1. Count 11 is 15 years to serve 10, concurrent with 10. 12 merges to 6. 13 merges to 7. Count 14 is 15 years to serve 10, concurrent with 10. 15 merges with 3. Count 16, the aggravated battery, is 15 years to serve 10. That merges, that runs concurrently with count 10. Count 17 was a directed verdict. 18 is 5 years to serve, concurrent with count 1. 20 is 5 years to serve, concurrent with count 1. And then 19 has to run consecutive to 10. It is 5 years. It is probated. That should add up to a 40 years to serve 30 partially parolable prison sentence with the balance on probation. Let me talk to you both about your appellate rights, because this would relate to any motion, Mr. Pritchett, that you're going to file. You both have the right to appeal your conviction and sentence. You can appeal it directly to the Court of Appeals. You also have the ability to file a motion for new trial. You both have the right to appellate counsel to assist you with all that. Mr. Robinson, I'm going to ask Ms. Mignot to consult with you and at your direction file either the motion for new trial or the motion for a direct appeal. And you can actually do both, but they have to happen in a certain order. The first thing that would happen would be the motion for new trial. That's something that I adjudicate. So it's a hearing in front of me about errors I made or errors your lawyer made. And so you would get a different lawyer to help you with this. And one would be appointed to represent you. If the motion for new trial is denied, then you still have that ability to appeal to the Court of Appeals, and that same appellate lawyer would help you with that. So none of this you have to do on your own, although you have a right to represent yourself. But I will ask Ms. Mignot to file within the next 30 days, one of those two things, if your direction is for her to do that, the motion for new trial, which is just a placeholder, and then another lawyer will flesh it out, or that motion for direct appeal. You have another appellate right, which is called a habeas challenge. And that right doesn't even kick in until you're done with all your appellate rights. You don't get a lawyer for that unless you can hire one. But again, that 4-year window you have in which to file a habeas challenge, that 4-year clock doesn't start until you've exhausted all your appellate rights. So it's not running right now anyway. The important thing is for you and Ms. Mignot to talk about whether you want to go ahead and go straight to the Court of Appeals or do your motion for new trial first. And then Ms. Mignot can file a 1-page document that says we're doing this one or that one. And then we'll work to get you a different lawyer. Not, you don't have to. I mean, you can talk with Ms. Mignot about it, but she will likely advise you to get a different lawyer so that lawyer can critique not only how I ran the trial, but also critique how Ms. Mignot did what she did, and thereby provide you a full scope of appellate arguments. And Mr. Pritchett, you have those very same rights to appeal, and assuming you qualify for appointed counsel, which I assume you do, meaning qualify financially, I can appoint a lawyer for you, but you're going to need to let me know that, because right now you said I want to represent myself. And you can switch back to having a lawyer represent you, and then I will appoint someone. It won't be any of the lawyers who worked with you before. It would be an appellate lawyer trained in appellate stuff. And if you want someone appointed, then I'll make sure that happens. And then that person can consult with you about whether you want to file a motion for new trial or a direct appeal. And again, you can do both. But if you're going to do both, you start with a motion for new trial. If you win that, then that means we have to do this all over again. But if you don't win the motion for new trial, if I deny it, you still have that direct appeal right to the Court of Appeals. Let me start with you, Mr. Robinson. Do you have any questions about the appellate rights I just shared with you?
No, Your Honor.
Okay. Mr. Pritchett, I'll let you share with me your question about a motion, but do you understand the appellate rights I shared with you? Okay. Do you still have a question about filing a motion?
So I can't, overly file a motion, 2 motions today?
So it would probably be only one motion, but you may have a different motion I haven't thought of. But the way it would have to work would be in writing. You can get something on the record if you want, but for it to be an official motion, you'd need to file it. But I will stop the clock for you if you tell me you want to have a lawyer represent you until we can get that lawyer appointed. So you won't, because you only have 30 days to file either the motion for new trial or the notice of appeal. You can file either one. And if you know which one you want to do, you can go ahead and file it. It can be handwritten, Maxx Pritchett. I want a motion for new trial, and that'll stop the clock and we can get you the lawyer. But I'm happy to toll the clock for you to get that lawyer if you tell me now that you do want representation. If you know you don't want representation, then there's no clock for me to stop. In the next 30 days, you just need to file that placeholder. It doesn't have to be perfected with all the grounds. It just be, this is my motion for new trial. You can't do a full-blown motion for new trial until you get a transcript of the trial. It just stops that clock, and then we wait until Ms. Rivers creates the transcript of the trial. And then whether it's you or that lawyer who's handling your appeal for you, that person goes through the transcript to see where he or she finds potential errors that I made.
I would like representation to stop that clock.
Okay.
But I just did one other motion that I was to file was a motion in the rest of judgment.
Okay. So you may want to talk to the lawyer about that, about how that works and whether you can do that at the same time you do a motion for new trial, or if there's a certain sequence, and what the deadline might be for a motion in arrest of judgment. And if you've got concerns about that, you could always file one yourself, because until you have a lawyer representing you, anything you file is a motion of record. As I think we've discussed before, once you've got a lawyer, it's not necessarily a motion of record if you file it, because it really should go through your lawyer, although the law has changed on that recently. But certainly right now, anything you file, that's a motion of record because you represent yourself. But what I'll do with my staff is work on getting a lawyer appointed to represent you, and I'll make sure that the 30-day clock doesn't start running until that appointment's made, so that you and that lawyer can have a conversation about which way you want to go, whether it's motion for new trial or direct appeal, plus whether a motion in arrest of judgment is the procedurally appropriate vehicle right now. All right. Mr. Hiles, anything on behalf of the state? Did I mess the math up?
No.
Okay.
My only question is, I think I know what the court, what they intend to do. I just asked if you put on the record whether Mr. Pritchett's sentence is to run concurrent with his 18 SC case, the death penalty.
Sure. I will repeat. I hadn't answered that. Thank you for doing that. I will repeat. I know I said it to Mr. Robinson, but it applies equally to both of you. You get credit for all the time you've been in, just many years, towards the sentence that I imposed, which is also many years. But Mr. Pritchett, I intend for your sentence in this case to run concurrently with, at the same time with your revocation. So it's not finish your revocation and then those other years. Those clocks will be running at the same time. And you've already booked a bunch of time as to both, but in particular, the sentence imposed here. Thank you for flagging that. I had forgotten about the revocation piece. All right. That is where we are. I appreciate everyone's time. And Mr. Pritchett, we'll get to work on getting that lawyer appointed for you.